Your recording will be permitted during the session. Also, you're not allowed to leave this hall during the session. So kindly adhere to the decorum of the forum. Greetings, judges. Welcome to the final rounds of the 25th Kerala Law Academy Client Consulting Competition 2025. Here, this is the final rounds, and this is session one, chamber one, with team code L. For the convenience of the forum, participants, could you please identify yourself? Thank you, participants. I request all the audience present here to kindly switch off your mobile phone. Audio video recording will not be permitted during the session in order to maintain the confidentiality. And the audience present here, do not leave the meeting, leave the hall unnecessarily. So thank you. I hope all of you will adhere to the decorum of the forum. Thank you. So participants, I hope you're not having a pre-consultation session. Could you please confirm that? Thank you. With the permission of the judges, can we proceed to the rounds? Thank you, sir. Participants may please note your time begins.
We hope you didn't face any difficulty in finding our office. Not at all. Have some water, please. Stay hydrated considering it's really hot out there. So,
Thank
is
you.
this your first time in a law firm?
Yes.
All right. So, before we begin, can you introduce yourself by telling us your name, your age, and what do you do for living?
Yeah, my name is Srijit. I'm 68 years old and I'm a pensioner from Central Government BSNL department as an engineer.
So, yes, Mr. Srijit, before we move into session, just to give you a brief introduction about the firm, fee details and all.
Okay.
So, our firm, NLA Legal, has been extensive leading in various areas of law, and we do have strong specialization over the property law, family, succession, contract, etc.
Okay.
And our firm has been in business for more than 2 decades, and as attorneys, we have been practicing for more than 5 years as well. So we are
Okay.
here to provide you with best-in-class service and assist in making an informed choice as possible. And we will try to accommodate all your needs and interests as you express them throughout the course of today's session. So safe to conclude, you are in safe hands. Please feel comfortable during today's discussion. There is no need to worry about it.
Actually, that's all what I need.
Okay.
That's why I'm here in front of you.
Okay.
Okay.
And secondly, the reason why both of us are assisting you today is that to bring the experience of both of us to the table so that we can provide you with the most effective solution. And additionally, in the future, one of us is not available at any point. The other attorney is equally familiar with your case.
Okay.
Okay.
That's good.
Yes. And lastly, during today's discussion, if we use any terms, legal terms that you don't understand or you are not familiar with, There is no need to worry about it. You can definitely stop us, and we are more than happy to explain the meaning of those words in simple terms.
Okay.
However, we will try to avoid using such words in this conversation, and we will make sure that this conversation is like this discussion is simple and easy as possible.
Thank you so
Okay.
much.
So that being said,
Yes, so as you have mentioned that this is your first time in a law firm,
Really.
before we begin this session, let me then explain you some primary things how this session is going to be.
Okay.
So the first and the most primary aspect is this session will be completely confidential in nature.
Mhm.
You shall see us taking notes, but it shall remain under lock and key.
Okay.
Since this is a client-centric session, you will be entirely in control of the information you are going to convey to us. But we would want you to be as open as possible since this is a collaborative effort to ensure that we come to a perfect solution for your problem. We will also be signing a non-disclosure agreement. It already has our signatures in it.
Okay.
So what it would do is whenever you try to communicate anything to us, it won't be shared to a third party unless you explicitly give us a consent to do so. But there's a little exception to it. So throughout the course of discussion, if we come to know that the party has committed any criminal offense, we might have to report it to the relevant authorities. But I'm pretty sure we won't reach to that point.
No, no.
Right. So, secondly, this session will be of 25 minutes. Firstly, you briefing about your issue. Secondly, us asking relevant questions regarding the issue.
Okay.
And lastly, the fee structure. The first session of our film, the session we are having right now, is free, of course. That is our policy. Post this session, if you wish to continue. Post this session, if you wish to continue our services, we will be giving you a retainer agreement and a fee structure, and it's your choice whether to sign it or not.
Okay.
Also, if this is a case involving financial crunch, we also take up cases pro bono. All right. So, lastly, as a matter of policy, if this is a case seeking relief against any of our pre-existing clients, we might have to end this discussion immediately, and thereafter we may refer your case to any other attorneys if at all you want us to do so. All right. So, that being said, L2.
so here is the note part for you, just in case you want to write anything throughout the course of today's session.
Okay.
So you may jot it down. Okay. With this, we hope everything is clear so far. And do you have any questions regarding what we have just explained?
Yes. No.
No.
I'm okay with it.
Okay with it. Okay. So just a gentle reminder, we encourage you to be as open as possible because it will help us in crafting an
Sure.
effective solution
Sure,
for
sure.
this. So, okay, great. Now, would you like to tell us now why you came here today?
Actually, I have a problem. That's why I'm here. It's a, yeah. I do. Your suggestions were given by my friend. So she introduced the firms to me. She's my colleagues, my neighbor. His name is Maya. Yeah. That's why I'm here. So I need a remedy for that problem which has happened recently in my life. Okay. My wife's name is Bindu and she died she died last year. Actually, my problem starts from there. Her Actually, she is restraining me from entering into my wife's property and she is claiming that the property belongs to her. That means my wife's sister is claiming that the property belongs to herself. So I'm not sure that why she is claiming like that because after the demise of my father-in-law, my wife has purchased the shares of my sisters. Okay, she purchased all the shares of my sister at the nominal price during that time. And now she is okay, filed a case in the court restraining me from, I mean, she filed an injection suit in the court restraining me from entering into the particular plot and also alienating from the property. So I wish to give this, the said property to an orphanage as a gift. So after knowing the details that why I'm going to do the properties as going to give the property as a gift to the orphanage, she is doing this to me. So I am here to discuss the possibilities, the law possibilities in this, and I need the property. I mean, I need to elevate the injunction suit from the third property. I need to do the further procedures. That's why I'm here. So I hope that you can help me out.
Your wife just died last year, and you're trying to do a good deed by giving the property to the orphanage, but your wife's sister is claiming that property to be hers. So before we move into the remedies and solutions, we would like some clarifications regarding the issue. All right. So,
Sure.
so what kind of property is being disputed here? What exactly is the property? Is it a land?
It's a land. It's a land.
It's a land.
It's a commercial plot. Actually, it's a heart of the Trivandrum city.
So could you please mention the exact date in which your wife passed away?
My first name in the 5/10/2024.
You mentioned that your wife bought this property from your sisters back then.
Yes.
How exactly long was it ago?
Actually, it's in 1987. The exact date is that 12/12/1987. She has bought the shares from the wife. My wife bought the shares from her sister. Yeah, the property actually first belongs to my father-in-law. Yeah. And father-in-law gives the property to, I mean, half the shares is given to my sister. And after that, my wife also bought that particular, and it's a 60-cent property. Okay. So it's totally in 60 cents. And it's divided into two equal shares, and one shares were given to my sister, my wife, and another share is given to my sister. So after that, my wife just bought the entire property from that, another 30 cents after giving the nominal amount at during that time.
Does your wife have any other siblings apart from your sister? Or is it
No,
just-
only two. One is my wife and the other one's sister. Sorry, I didn't get you. Yes, yes.
property right now?
Yes.
Are you maintaining the property? Like,
Yeah, I'm giving building, I mean that particular revenue tax, etc.
your wife wrote any kind of bill regarding the property?
My wife. No, there is no will written by my wife because there's a proper documentation for the said property that my wife had bought the entire property, that's sale deed, etc. No, no.
You said that you are also paying tax.
Yes.
And you also mentioned that it's a commercial land. So, okay. Right. So you said that the land is a commercial one, right?
Yes.
So what exactly is it? Are you doing any business, or what exactly is going on that?
No, no, no. Now I mean, like there's a building in the particular land, but now it's just closed.
What building exactly was it?
It's a mini shopping complex.
Mini shopping complex. And when did the complex got closed?
Few 10 years back.
10 years back.
Because I am not in a position to look after that, so I am residing.
So right now it's just a barren land.
Vacant
And
land.
there's
The building is there.
and you are paying the tax too.
Exactly.
Right.
Whether any other siblings have a problem regarding this?
There is only one sister.
Okay.
Me and my wife and one sister is there only. There is no other siblings to her. My
Okay.
wife is passed away and only the sister is in possession.
Okay.
Yes.
So, whether you try to contact with your sister, like wife sister, after this?
Yeah, I tried many times to contact her, but she is not ready to talk with me. I had also already sent a mediation, I mean, already mediator me because I am not in the particular place where she lives. I'm far away from the place. So I just sent a mediator on behalf of me, but she also rejected the same mediation talk.
The injunction suit filed against you
I came to know that 2 months back.
2 months back. All right.
Actually, I said that I'm not in a particular place, so I get the details just little bit delay.
So were you evicted from your property? Oh, I mean, oh, okay. They took over the property, right?
Yes.
So after taking of the property, did they, after possessing it, did they cultivate on it anything?
No,
That
no, 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 no. Actually, they are claiming it wrongfully, right? Because I have all the documents with me that the plot is belongs to me, and why she is claiming that I don't know why she doing this to me.
So, did they made any public accusations or the defamation, or they tried to hurt you in front of the public?
There is no emotional or that kind of talkings from their side. Actually, they are worried that the plot will just go to the orphanage. That's the reason why they are doing this too. Yes,
intention with the property after taking it?
I don't know.
You don't know.
Yes.
So you also said that you have been receiving any threats, no type of defamation, nothing. That's it. All right. So you also mentioned that you would prefer mediation. What was your wife's sister's response to this?
Yeah, I already told you that I had sent a mediator, and I
Mhm.
also tried to call her in the phone and her husband's phone,
Mhm.
but no replies or no other positive response from received from her side.
So, are you concerned about your family reputation? Right, like if you move for the court, like it will take the time and there will be long process of the litigation. So, if any possibility is there, will you be open for the outer court settlement?
Yeah, I am ready for the mediation because I already told and I have already given the details, right? So it's really favor for me.
Also,
So I am ready to do the mediation and I'm willing to
yeah,
do the
understandable.
Yes.
Also, do you have documents relating to your wife buying shares of your her sister back then?
Yes, yes, yes. The
Uh,
sale deed, etc. This belongs. I mean, it's with me.
do you have the original
I have
documents?
the entire details. I didn't bring it today. I can submit it the next city. Is it okay for you? Thank you.
You said that you're having possession right now, so you will be paying the electricity bill, tax, everything.
The electricity got disconnected as it is not used for the last 10 years.
10 years.
And there is no water connection in that particular building.
Okay.
And I am paying the tax revenue for the land as well as the building
So,
regularly or through online. So I have all the receipts with me,
Okay. You have all the documents with you.
except.
it was 2 months ago. You are the one still paying, right?
Yes, yes. And for an addition fact, in between the 2 months, I didn't pay any tax because I already paid in the last March.
So that being said, we do have a strong case at hand. I know this is a really stressful situation for you,
Yes.
but yeah, as attorneys, we have handled similar cases before.
Mhm.
So you are at safe hands. So before we, there are a lot of strengths in this case. So you mentioned that this property was received to your wife by her father-in-law, and the property was divided.
Her father, from her father.
Yeah, from her father, and the property was divided equally among the two siblings. So also, just to clarify again, all the your wife's parents got married according to Hindu rituals only, right?
Yes, sure.
You two got
We
married.
follow Hindu
Yeah.
marriage.
So according to the Hindu acts we have in India right now, after she bought the shares from her sister, she becomes the absolute owner. So even after she dies, she cannot claim back and come right now and say that, oh, this property belonged to her, to my father. All right. So the property will be with you only. Uh, and also, let me give you some general advices regarding this session. So, firstly, we would want you to keep all the documents we mentioned right now,
Okay.
the tax deed one, the sale deed documents, and all the receipts, any tax receipts, any such things safe with you.
Mhm.
Also, while communicating to your wife's sister, do maintain a civility, since you might not intend to say anything, but they might take it out of pocket and it can be used against you in the court of law. So while communicating with her, beware of everything you say. And also if they
Sorry to interrupt in between. Actually, I just tried to call her, but
Uh-huh.
she doesn't receive my call or she doesn't try to me take the calls. So
Right.
there is no communication where
Okay.
actually connected to her.
Even at any point if she picks up
No.
right.
Yeah.
Okay, fine.
Actually, the at the first point that she comes to know that I am going to give the entire property to an orphanage, she got agitated and she started to do the other procedures that he needs the property.
Okay, fine.
Yes.
Yeah, understandable. So what I said was, if at any point she picks your call or she contacts you, or do maintain the civility, and as I have mentioned earlier, keep the documents to safe with you. And if the lawyer of your wife's sister tried to communicate with you, do send them our contact so that
Sure.
we can avoid any kind of emotional manipulations in this case. And also, do not sign in any documents, anything they are going to give to you, so that if this case doesn't get more complicated. So let's move into the remedies side.
Could you, I need one more clarification.
Yeah, please.
So, you said that you came to know that your sister, like wife's sister, filed an injunction 2 months back. So there was a 2 months gap. Could you clarify regarding what was really happened in between 2 months after
I came to know about this injection just few days before.
few days before?
Yes. Actually, the injection were filed that it's been between the 2 months, and I came to know this few days before.
Okay.
That's the difference between these days. That
Okay.
has happened in between these days.
Okay. Fine. So there
Actually,
is.
I am said that I am not in this residing place, so the communications were really got lagged.
Okay. Okay. We understand that.
Yes.
So first of all, there is no need to worry about it. We do have strong case at hand, and we understand that this would be a stressful situation to deal with if, after your wife's death. But under law, there is always a way to solve the things, right? So we do have the remedies, short-term and the long-term remedies.
Okay.
Short-term remedies are those remedies that we would pursue like immediately. We would take up the action immediately. And long-term remedies are those remedies that we would pursue afterwards. So short-term remedies, like first of all, what we have to do is we have to keep all the documents at hand, all the documents that related to the property that you mentioned that you
Yes.
have, and also there is also evidence that indicating the enjoyment, right, regarding tax receipts, everything you have to keep at hand, and also and our main course of action would be defending the suit. So first of all, we will try to, like you mentioned that wife's sister has already filed the suit before the court.
Protection.
Yes. So we have to defend it.
Okay.
Yes. Yes. Basically, we have to defend it. For that, we will be like writing the written statement.
Okay.
So in that, we will be clearly mentioning about our defense, preliminary defense, and that you have been like your wife's properties acquired in that way, and you have been paying all these things, and you have all the documents at hand. Course, like we will be mentioning everything in detail there. Okay, so that would be our main course of action. And we do have, like you said, you want to settle this case peacefully outside the court. Since
If it is possible, I am ready to do it.
yes,
Yes.
we can try that, right?
Sure.
Okay. So we do have the alternative dispute resolutions, so mechanisms. So there are certain classifications there. We do have the mediation and the negotiations.
Okay.
In the negotiations, there will be two parties that you and your sister, like wife sister, will be sitting there, and with the counsel presenting. So they will be, trying to talk to each other and coming to an understanding about the problem. So that will be how the negotiations work. In the case of the mediation, there will be a neutral mediator, and he will be helping to reaching a solution. Okay, so it will not be binding, but he will be helping to reach to a particular solution. So yeah, this would be outer court settlement, and it would save time and also the money.
Okay.
Okay.
Out of anxiety, I am asking you that. Is there any way that my wife's sister is going to get this property? Is there some provisions or somewhere like that? Because I don't know about the law. Because I am basically an engineer, so I am very much not aware of this particular law. So I am very much tensed. That's why I am asking this question to you. So if
So-
there is any way, you should have to prevent it, right? Yeah.
So we do have the act named the Hindu Succession Act. So specifically under this section 14, any property received by the a woman, that woman will be the absolute owner.
Okay.
Okay, she can do whatever she want to do with the property.
Okay.
So
So since you mentioned that she died without writing any will and you do not have any children too,
Yes.
so you will be the class 1 heir of the property of your wife,
Okay.
which was acquired by her. All right.
So how she managed to get that injection for that particular loan? Because all the documents were with me, right? So how she, so was there is any possibility that how she managed to get that injection suit without even knowing me?
Um,
I'm asking out of anxiety. That's why I need to know the reasons.
Maybe we might need to look into the sale deed which you mentioned earlier, right? We
Yes.
might need to check if there are any specific clauses
Okay.
or anything that such which says that if she dies the property might go back to your sister, but but it's not
That's why I'm asking that. Is there
yeah
any provision
yeah
saying
yeah
that my
after
sister is going to get the
yeah, I
property?
think
I'm really tensed and
yeah
I'm in the back of this after knowing that she's filed a suit. I mean injection. I'm
yeah
just
yeah
googling it, watching some videos, etc. So
right
from that, all the details I'm gathering, and after
right
that, I'm sitting here.
right. So for that we might need to refer to the sale deed which your wife executed back then.
Yeah, I
And
will get it to you.
yeah, and also the gift deed your father-in-law the property was received by your wife and her sister, right?
Yes.
We might to check that deed too and check if there are any specific clauses, any exceptions regarding this. But as far as our knowledge and understanding, since you have been possessing the property without any dispute, without with peace only, and you have been maintaining the property, you have been paying the tax, the court might consider your side. All right. So
Okay.
need not worry at all for that now.
So I'm little bit I'm very much nervous because before I'm coming to this room, but now I'm very much lighthearted after hearing from you that there is no possibility to evacuate the property to her sister. That's a very great news.
basically, this was just the preliminary session. So,
Mhm.
what we understood, like what we said was what we understood from the preliminary discussion.
Okay.
Once we have to look into this sale deed, like any specific clauses regarding whether this property will be going back to the sister.
So I
or-
hope that there is no clause in like that.
Yes.
I'm also not sure about it, and you can refer it.
The secondary session, you can bring us those documents
Sure.
and we will refer to you and tell you that. So
So one more thing is that did you mentioned that you purchased the your wife purchased the shares from the father-in-law
No, from my sister, from her sister.
sister. So that time, did you ever financially contributed to the wife?
Yeah, I'm the she's an unemployed woman, so I'm the person who give the money for the purchase.
Strong point. Basically,
And also at that time, I had spent a lot of money. They say 50 lakhs amount is spent to purchase the said amount, said land. Yes,
so how much money like did you give to the wife?
50 lakhs.
50 lakhs.
Yes. During that time, I mean 1987. Yes.
so that being said, from our preliminary understanding, you will be fine only. So before
good
we
to hear.
yeah, so before we conclude, these are our business cards.
Okay.
L2 will be your point of contact 1 and I
Okay.
will be your point of contact 2. You can contact us anytime, 24/7. We will be available.
Okay.
And these are the documents that we would require you to take: retainer agreement and the fee agreement.
Okay.
And there is no need to fill them out right now. You can fill them at your convenience.
Okay.
Okay. There is no
I will
need
go
to-
through all the documents, and after next section, I will sign it and come to you.
Basically, okay. Yes, I will be
Is that okay?
contacting you. Okay.
Okay.
So just to explain, today was our preliminary session,
Mhm.
introductory meeting, and
Mhm.
second session will be scheduled once we have all the documents at hand, the everything that we mentioned, especially that the 15 lakhs we financially contributed to the wife during that purchase. So all the other documents, once we have all documents, we will be having the second meeting.
Okay.
And also there will also be a third meeting to conclude the course of action. And this number of the meetings are not limited to 3. It may depends upon the
Yes,
course
yes,
we
yes.
take and also the further documents that we may require. And what we said is just suggestions on our preliminary understanding, and you are not bound to follow it. You always have an informed choice. it is at the end your choice whether to accept it or reject it. So you can deliberate upon it. Okay. So I
So
think
before getting what's the fees I should have to pay for each sections? What's the fee structure?
As we mentioned earlier, the first session of our film is entirely free, of course.
Yes.
We have mentioned about the fee structure here in the fee structure annexure.
Okay.
You can go home and check regarding it.
I will go through the documents.
Yeah, sure,
Yes.
sure. So
Thank you.
thank you so much. Thank you so much. It was great.
it was pleasure having you.
Yeah, sure. Thank you. Yeah.
So L1, what do you think about today's session?
So I believe this session was really productive. The client was really forthcoming, and he did give us all the relevant facts we need in this case, right? And also, we need to discuss on the malified intention from the side of the wife's sister, because the property which no one was using when it was going to be given as a gift to the orphanage, now they suddenly need the need that property. What do you think?
Yes, definitely. We do have a strong case at hand. And the important point is during the time of the purchase, he's the one who financially helped her to purchase that property. And also, he's the one who is paying the taxes and all those things. And it also ensures that is the one who is maintaining the property in a proper way. And since there is no will regarding this, that would be give to like that would be divided among like class of heirs for son, then daughters, then the husband. Since they mentioned that they have no children, like no adopted or either biological children. So yeah, it will be go back to the husband.
Yeah, I do think that. But since he said that he received an injunction from the court 2 months back, we might need to look more into it, because a property which was purchased by his wife with the money of our client, how come the injunction happened? So after we receive the after we receive the documents regarding the sale deed and the gift deed from back then, we can check if there are any specific clause, specific things, anything written to see how this injection exactly happened.
Yes, I do think that. And what do you think about what are the provisions that we can apply here?
Yeah, definitely the Hindu Succession Act, since the marriage has been conducted according to the Hindu rites, and the section 14, which says that, which speaks about the absolute ownership, since the property has been bought by the sister with the money of the client, she is the absolute owner. So because she died without writing any will, according to the class of heirs, it should definitely go to the husband. What else do you have to add?
Yes, so we also have to look into section 15 clause 1, 15 clause 2, especially in 15 clause 1 in the case of the self-acquired property. The class of heirs are listed, like I mentioned, son, daughters, and the husband. So since they have no children, it will be going back to the husband. So, and also we have to, here in this, we have to consider the financial contribution about the 15 lakhs made by the husband. In also, in the 15 plus 2 is actually an exception if it is an inherited property. But actually, this is she actually purchased the share with the financial contributions by the husband. So I think we can deliberate more upon the section 15 clause 1. And also, we do have the precedents by the Supreme Court regarding this, especially in the case of the Om Prakash judgment. Yeah, saying that if there is no there is no children, it will be going back to the husband itself if it is in the case of 15 close one.
Yeah, we do have a similar case from the Supreme Court judgment, right? Also, about the documents we need from the client during the next session, what all should it be? It should be the sale deed one, all the tax receipts, the payment bill of the 15 lakhs rupees. Then, if the gift deed, if he has one, and also the maintenance he has done on that land, right? Also,
So what do you think our next course of action should be?
I think we should divide our work around, right?
Yes.
So I will be writing a written statement to the court, describing about the situation of our client. I will be showing his sides, how this property was bought by his, using his money by his sister, and why, how come this injunction happened. Also, I will check into the sale deed, etc., to see if there are any specific clause related to it. How about you?
So I think I can contact the client once again. So whether he want to continue our service or not, first thing. And second thing is that we have to ensure that he's in the peaceful manner, like he's not having any other confrontation with the sister. Like there is no other issues regarding that. That he's not receiving further any other threats or any kind of things from her, like the sister-in-law. And additionally, I think he's also open for the outer court settlement. And since I can actually contact both client as well as the sister-in-law for the if there is any chance of outer court settlement. If there is any scope regarding that, we can opt that either. I think the mediation would be better. So what do you think?
Yeah, I too agree to that. I don't think we need to drag this case to the court, considering he just wants the property to be gifted to the orphanage, nothing else. He doesn't want to use it for himself or anything, just for the orphanage, right? So, that being said, do you have anything else to add?
Should we take like what about our okay?
Pro bono.
Yes.
So we can talk with the client. Let's see his financial conditions, and if he's going through any financial crunch, we can consider taking the case pro bono.
Basically, I can deliberate more upon after like today's session. I can contact with the client whether he's having any financial crunch. We can consider regard after that. Okay.
Right. So that being said, think we should get on with our preliminary research. Will you be free at 10 a.m. tomorrow?
Yes, definitely.
So let's meet at 10 a.m. then. It was a great session.
It was indeed a great session.
Thank you so much.
Thank you.
Uh, the suit was filed for
No, no. Is it a declaratory suit or is it a simple injunction suit?
simply a injunction suit as told by our client. We might need to check into the case or the file details to look more if it's anything specific told there.
When it is a simple injunction suit, what you should do when there is an interim order of injunction? Immediate remedy.
So we will write a written statement to the court and explain the situation, and also tell about the shares which was brought by the.
What is the life of an injunction order? An ex parte injunction order.
Basically, it can be a temporary injunction or also permanent injunction.
What is the nature of the injunction right now?
As the client mentioned that he's from an engineering
No,
background.
is it an interim injunction or is it an ex parte injunction or is it an absolute injunction? Is it a permanent injunction? And if it is a permanent injunction, how does it take place?
Regarding what type of injunction is it, we might need to look into the injunction document.
And if it is already a permanent injunction, what is the remedy that is open to him? Does the CPC provide him any remedy? What is the remedy?
We might need to look more
What is the
into.
provision under which a temporary injunction is passed?
So there is also order 39 of the CPC regarding
Uh,
Okay.
The first question you had been putting before going into the merits of the matter, you were saying that one non-disclosure declaration will be the client will be you will be giving to them or to the client. Is it any statutory requirement or is it just a policy of your firm? Is it always required that a lawyer should execute a non-disclosure declaration to his client? Is it something mandatory under the Advocates Act? Or is it just a policy of your firm?
So basically, the communication with the client is a privileged communication.
Yes.
So we do have the provision 127 of the BSA, 127 of the BSA. It is a privileged communication so that we'll be having in confidential in nature. And yeah, so
True. Should it be given in writing to a client? Or does not the statute mandate that even without giving that, is not a lawyer bound to maintain it?
Something a lawyer is bound to maintain, but just to make our client comfortable and to tell him that this will be anyway confidential, so that we can extract more facts from it. He might not know, right? If we will tell this outside.
Only to instill more confidence in your client that you are offering to give such a declaration. Is it so? When the client executes the wakalat, that itself is a contract
Yeah,
between
that
you
is-
and the client that you will be acting only in accordance with the Advocates Act or the relevant provisions. You will not divulge any information regarding to the other parties.
Yes.
You'll keep it confidential. I'm just asking if over and above that, any such declaration is also liable to be given by each and every lawyer to his client at the time of engagement. You might have to probably look into those aspects also by way of caution in future, whether any such document has also to be given to the, because normal practice is not given. Need not be, even without going into that, or the client can always say, my client, I'm a lawyer, acted beyond the the engagement, and he has gone and disclosed this to the opposite side. He can go to the bar council and complain, etc. Is it not?
Since we are giving them a written file with our signatures on it, it can be, let's say, of course, written
Fine,
statement
fine.
that
Exactly. Excellent. All right. Fine. And we'll put you the other questions.
I think you've been asking so many questions to the client. And you said that, basically after you see the documents that he will produce, thereafter you will be able to come to an understanding as to how strong your case is, etc. But don't you think the basic thing that you should have asked is, when did he get notice, whether he got notice? If he has got notice, where is the notice and what are the pleadings in the application? Because he says that he came to know 2 days ago and this happened 2 months ago. So obviously he has been served with the notice, which means if it is served, then you should be, the first thing you should look into is what the other side has filed and what are the pleadings. Don't you think that was the basic thing that you should have asked? Or is it that you missed it? Because you are actually engaging a client who is not a plaintiff, going to be a plaintiff, he is a defendant. So there is already a proceeding. So when he comes to you, he is coming with an issue where he has already got notice. So the first thing that you should find out is, first thing you should see is, what has the other side said in court? So therefore, instead of going to, into his documents, basically listening to him, you will understand what he has. Now, but before that, you should understand what the other side has already stated in court. Don't you think that should have been the first two questions that you should have asked him? Just a thought in my mind. What do you say?
Yeah, it was something I think we should have asked in the beginning, and I think L2 will contact the client today evening regarding that issue.
Yes.
Right.
Yes. Thank you.
Yes. Don't you think that more than section 14, the section 15 too will come into play in the instant case under the Hindu Succession Act?
Okay, this is an exception, but we can't completely say that it is an inherited property from the wife's parents.
Yeah.
So, since he's also made the financial contributions for purchasing the shares, so I think that the 15 clause 1 would be coming to the place.
Come into play. See, 14 will come only if the property is possessed by a female Hindu, whether acquired before or after, becomes a full owner. Here, the sister is also now claiming a right on the death of her father. She was having one third right, mother was having one third right, and sister. The mother's one third right has gone to the both the sisters. Is it not?
How do one third rights?
Yeah, mother's one third right should go as per that. Then now they said as there was a will by the mother, and that should go to both sisters.
The client didn't mention anything regarding the will. We did ask the client if there are any other wills.
So that's why the senior brother was saying, should you not have then gone into the pleadings to get the actual facts of the case? Otherwise, it will be an exercise in futility, merely to put a hypothetical questions and then ask him what. So the first thing, the foremost thing should be what the other side has said in their pleadings. All right. So that's where this mistake, I mean, this kind of thing will happen. Yeah. Then. Hold on.
Look at the things.
Sure. Nice. Good.